Hey, so today I have a evidence essay to go through. This is the 2017 February California bar exam. Question number three. Evidence is a subject that a lot of people have issues with just because there are so many exceptions, particularly for hearsay. And, a lot of people have issues, no pun intended, with uh, keeping track of all of that. And something that's unique to evidence is that for each piece of evidence, there are some certain things that you do have to go through. This is something that I struggled with when I studied for the bar exam. So I thought this was a good candidate for me to make a video about so that hopefully it becomes easier for you. So let me see. I'm going to move myself here. All right. So let's go through the fact pattern and then go through the call of the question as well. And then as we go through each call to question, you will see how I break down the issues that we do need to go through every time and break down hearsay exceptions. So even though it looks complicated, and I think it's actually fairly complicated, uh, it should become pretty, it should look doable. And, I picked this one just because there are several issues under hearsay and relevance issues. So let's just jump right in here. So I'll go through the facts here. So we can tell right away that we have a civil case, Pete versus Donna's Pizza. So it's not a criminal procedure, um, which means that there are some exceptions that will not apply in this case. So for character evidence, there's a criminal only exception. And in California, there's a Prop 8 exception. So neither of those will be discussed here in any shape or form. All right, so we have Pete testifying that he was driving his car. He entered an intersection with the green light in his favor. That's what he's trying to assert. And he's saying that when he entered the intersection, Aaron, an employee of Donna's Pizza, was driving a company van, ran a red light, and hit his car. That's his version of the story here. And he got into the hospital. He talked to Nellie, a nurse, who said that she treated Pete. She also said that Pete told her that during the collision, he got hurt because his head struck the windshield. He was in a lot of pain, and under standard practice, she recorded all this information onto a hospital intake form. And Pete wants to move this into evidence. So now it's Donna's turn. Erin testifies that she had the green light and that it was actually Pete who ran the red light. So we have some conflicting information here, conflicting testimonies. And Donna, the owner of Donna's Pizza, said that they were not responsible for the accident and that she never offered to pay for any of Pete's medical expenses. Pete comes back and says, number one, Erin told him that she was in a hurry to make a pizza delivery and that's why she ran the red light. And number two, she's saying that Donna told Pete that she would take care of all of his medical expenses, but that she never paid for any of it. So if you are somewhat familiar with evidence issues, you might have seen, you might be kind of thinking of certain issues. So that's what I call issue spotting. You kind of see what, oh, that looks like an issue. You just kind of pull out issues from thin air and then write down whatever seems appropriate, whatever seems right. I would rather approach this more systematically, more streamlined, more structured, so that you're not missing any issues that you need to include to capture all the maximum points that you deserve. All right, so let's go through these calls one at a time. So let's just write them down. And we want to come to some kind of conclusion here by the end of by the time we write the answer. So it's good to keep these organized. There are multiple calls. I just like to keep them divided like this. Hopefully you're a better typer than I am. All right, so let's go through the first one. And what I have here is a handy dandy issue checklist that connects the facts to the issues that you should bring up. So this is not a California criminal case, so we don't have to go through that. Let's check through the first things to check for each item, for each item of evidence. So in evidence questions, you want to consider each evidence independently as an isolated piece of evidence. So for each one, you do want to describe the logical relevance, whether there was logical relevance, legal relevance, and if it's a document, then you want to consider whether it was authenticated and meets the best evidence rule, or if it's a California case, the secondary evidence rule, which is basically the same thing. So let us type that in. Logical relevance, legal relevance. And so we're talking about the hospital intake form. So that's a documentary piece of evidence. So let's mention authentication and best evidence rule. And as I mentioned, these will be relevant. Well, these should be discussed for each piece of evidence. I'm just going to copy it over just so that we have them right. And we could go through the relevance analysis here, but you can maybe try to do that on your own and ask any questions in the comments if you have any. But I think that these are slam dunk issues. We do have logical relevance and legal relevance. There's no unfair prejudice that would prevent the weight of the probative value of the hospital intake form. So again, unfair prejudice is something that would be triggering to the senses, like something gory or explicit or sensitive. This is definitely not one of those cases. So these are very slam dunk issues. You do want to include them though. They will count for points. Same with the authentication best evidence rule. They may seem minor, and they are kind of minor actually, at least in this case, just because we don't really see any issues, or we don't really see any descriptions about whether this hospital intake form is the original or if it's real. Authentication is proof that it is what the proponent, in this case Pete, claims it to be. So I mean, there's not really something really to hash out here. So let's just bring it up and show the grader that we know what we're talking about. We know the issues under evidence, and move on. I think though that here we have an interesting scenario here. We have a piece of paper, we have the form, which talks about what Pete said. So does that trigger anything here? So let's I have this crude drawing of hearsay. So as you know, hearsay is when someone is bringing out of court statement to prove the truth of the matter asserted. So whatever here in the bubble is what is offered to be proven for. I don't know what the preposition I should be using there is, but you know what hearsay is. There's something called double hearsay or multiple hearsay, where you may have someone saying that someone else said something. So it might look like this if you were to draw it. So here Pete, or in this case the hospital intake form, is saying that Pete said something. So we have two speaking entities if we count the form as a speaking entity. If you prefer, you can kind of draw it like this. So we have multiple speech bubbles. And so here I've completed the figure here. We have Nelly, or the intake form, saying that Pete said something. So in this case, there's another way to think about it, which is, is X saying that Y is saying Z? So multiple parties saying something. It can get confusing if you have even if you have two people involved, that can just be single hearsay. Let's say, so Nelly, this is a pure hypothetical. Let's say Nelly says Pete did a certain action. Even though there are two people involved, since Pete is not speaking, there's no speech bubble, so that is still a single hearsay. But if she is saying, or if the intake form is saying that Pete also said something, then that's multiple hearsay. So let's write that down, and we'll set up the hearsay issue here. pull that just because it's a major issue. And how do we know this is hearsay? Hearsay is an out-of-court statement made by the declarant offered to prove the truth of the matter asserted. So here, Pete has moved this form into evidence. He is trying to assert whatever is in the form. He's offering to prove the truth of the matter asserted in the form. It is an out-of-court statement, out of this court, because it was made in the hospital, and he wants to use that to prove that whatever that was in there is should be taken as truth. So it's, if you do hearsay questions for long enough, it'll become obvious enough that you don't have to kind of think through it. But when you study these rules, like you want to know the elements, and you'll be writing this as a rule statement anyway. So anyway, just a little detour. So this is a multiple hearsay question. And what are the layers of multiple hearsay? If all of the layers of the multiple hearsay are admissible, then the entire multiple hearsay evidence, in this case, the hospital intake form, will be admissible. All right, so let's just write down the layers we have here. We have the hospital record, hospital intake form, I guess. And then we have Pete's statement, which is inside the form. So now we have to figure out whether each layer, the form and the statement, whether they are admissible despite being hearsay. So what do we know about hospital intake forms? Well, let's just go through the checklist here. So we found that it is multiple hearsay. Great. Is there other purposes that would allow this to be admissible? This is not really talking about legally operative facts. That's usually applicable in contracts or torts defamation. Defective listener, nope. Knowledge of speaker, nope. State of mind, nope. It's not a non-human source. There's not enough space in here to list out all the exemptions and the exceptions. So let's turn to my condensed cheat sheet, outline, magic sheets. Here I have all the mostly possible issues underlined here. So is this a prior inconsistent statement? No, this is not about prior statements or admissions by parties. So let's just move on. The statements against interest. Do you see anything here that might be? No, I mean, we're talking about an intake form. This is a record. So let's look for something documentary. So any of these will count. Business records. This is a record of a transaction or a testimony made near the time of the event. This was after the accident happened, with personal knowledge of matters. Nellie is the one asking Pete, so she has personal knowledge. And this was made during the regular course of business. This is pursuant to standard hospital procedure. So this sounds awful like a business record. So let's write that down. Do we have anything else? Are we trying to revive any recollections? Public records. So a hospital is typically not a public entity. It's a private organization, usually. And so this one is probably not going to be an issue. If you have the time, you can just jot it down and say, this is not a public situation. So I have an example here where we have a police observation record. So I don't think this is really a big issue. You can jot it down if you want, but I am going to keep it to business records. So we have a pretty good lead here. Let's look for what we can do with Pete's statement. So again, the Pete is saying that he got hit. He is in a lot of pain. Maybe the closest here might be state of mind, but I don't really think this counts as that. Let's just go through the list again here. This is not about prior statements or Pete is a party, but he is not an opponent whose statement he's trying to bring in. So let's skip over that as well. Let's see. The declarant is speaking, so he is available. Excited utterances. No, this is not during the excitement of a startling event. Definitely not that. It's not at the event. It is sort of afterwards. It's not immediately afterwards. Um, this has an emphasis in timing, so I'm not going to really go there. A then existing state of mind, emotion, sensation, physical condition, possibly. We can keep that in mind here. I'm gonna put this in brackets. Actually, I don't think this is usually what we consider a then existing state of mind, forward-looking intent, but I'll put it in there. Okay, so we have declarations of physical condition. That sounds quite a bit like the great deal of pain language here. So present bodily condition. This was not made spontaneously, so I'm not going to. I mean, we could bring it up and then dismiss it, but I don't think this is actually what is going on here. And what's really going on here is past bodily condition. So it was made to a medical personnel for diagnosis, treatment, or testimony. It was not made for testimony, but now it is becoming testimony. But anyway, this is likely for treatment because he was talking to a nurse. In California, this is not a California case, so we can skip over that. We hit the business records while we were analyzing the first layer, which was the hospital intake form. Let's move on. We're not trying to recollect anything. It's not a public record. Okay, so let's go with past bodily condition. And you can write down the rule and so on. Is there anything else about Pete's statement? I think that's it. There's some other exceptions that would allow it to be admitted, but anything else here? Yeah, I think we went through this already. State of mind, insanity, belief. Nope. So I think we're done. So we do want to answer finally the answer to the call to question. So what can we conclude here? So we can say pretty safely that Pete's statement is admissible because it was a past bodily condition. Statement, the hospital intake form is admissible because it was a business record. Therefore, all of the layers of the double hearsay are they have some sort of exception applied to them. So all of this is likely properly admitted. So you do want to conclude. Well, there will be conclusions for each of the issues that you talk about. This is the answer that you're answering the question that was asked of you. So do remember to ask the question that was asked. So I will write that down so that we remember. Okay, so that's the first call. Now we have Pete's testimony about Erin's statements, which is the first part here. So Erin told him that she was in a hurry to make a pizza delivery, and that is why I ran the red light. That's what Pete is trying to assert. But Erin said that she had the green light, and it was Pete who ran the red light. So we have some conflicting information. This is also a personal testimony. Let's go through the checklist again. So we got logical, legal relevance. We don't have any exclusions based in public policy yet. This is not documentary evidence, so we can skip that. It's not a judge or juror that's speaking, but we do have a witness here. Erin is a witness. So we want to consider whether she has competency or personal knowledge. So let's write that down. Competency. And this goes to personal knowledge. Well, put in brackets because that's what we're going to talk about. This Erin is not a witness with an opinion. She's just telling her story. So neither of this will count. There was an examination of a witness. This was actually done for me to. So this is here to get at certain types of evidence questions, which is you have a transcript, you have a question and answer. For those, you want to kind of have bring up other issues, not applicable in this case. So someone testified. I think we hit on this issue, which is still it's an issue, but it's a minor issue. But it does show the greater that the different preliminary issues that you should be talking about in this case. And what is next? So is the evidence a statement? Yes. So Pete is testifying about Aaron's statement. So we have another hearsay issue. Pete is offering Aaron's statement to prove the truth of the matter asserted. He wants to say that Aaron said this, so but then Aaron said something else. So let's bring up hearsay, and then we also want to go through whether it would be admissible despite being hearsay. In the checklist, we have other purposes. Do we have other purposes here? We not legally operative facts. It's not the effect of listener. It's not the knowledge of speaker or the state of mind. I think these exemptions seem pretty interesting. So Aaron's saying she had the green light. Pete is saying that Aaron told him that she didn't have the green light. So we have some inconsistent statements going on here. We definitely want to bring up prior inconsistent statement in this case. Let's underline that. Let's see here. So we do not have a consistent statement. Do we have a prior statement identifying a person after perceived? Nope. We have a statement by an opposing party. So that is definitely another one to mention. Admission by party. And let's see here. I don't think this is a statement against interest. That's fine. Adoptive admissions. We don't have any implicit conducts or silence. Okay, so vicarious admissions, that's also interesting because Aaron is an employee of Donna's Pizza. Let's see what we have here. Co-party is not a co-party. Is it an authorized statement? It was Aaron impliedly authorized by Donna's Pizza to speak on its behalf. Possibly, yeah. Let's as the driver, she was the driver, right? Yeah, she was an employee who was driving. As a driver, she can probably speak on behalf of Donna's Pizza. Let's put that there. She was definitely an agent. Put that ahead of authorized just because the fact that Aaron was an employee sounds quite relevant. So agents, guess. And then we don't have any co-conspirators here. So okay, so we have a couple of vicarious admissions hooks that we can say are could be potentially exceptions. What else do we have here? The declarant is available, so this is not really relevant. This is not an excited utterance. This goes to emotional state, and this is just Pete saying that Aaron said she had the red light. Nothing too exciting there. Timing wise, this is not at the time of event, or was it? I mean, it was afterwards, but it was not immediately after. Well, we can keep that in mind. Present sense impression, but this goes to timing, so the timing has to be quite close, almost contemporaneous. You could bring that up if you wanted to. I don't think it would be relevant, but excited utterances. Well, these two issues sometimes get compared. So if we're going to bring up present sense impression, we can also bring up excited utterances. Now, let me take out the bracket here. I think, let's see here, at the accident scene, I think it could go either way. I'm going to just keep it as an issue to talk about. But I think that's about it. We have I don't think it's a then existing state of mind. Declarations, nope. Of physical condition, nope. Not a business record. Okay, so I think we're good here, and I hope you're again a better typer. So because we have a few ways we can say that this, even though it's hearsay, it should be admitted. We have the prior inconsistent statement, which is the green light versus red light. Mission by party, statement by Aaron, a party opponent. So we have a few ways we can attack this. Okay, so this is likely properly admitted. And so far it's taking more. This is probably taking more time in real time than you should be taking. So if you are familiar with these issues, if you can go through the issues in your head, this should probably this first call probably takes about 3 minutes to come up with, 3 to 4 minutes. This one maybe 4 to 5 minutes. So all of this combined, I hope it would take about 15 minutes, probably maximum. And then afterwards, all you have to do is put in the rule by include. Well, in the case of logical relevance probably 1 to 2 paragraphs. Don't spend too much time on these preliminary issues like writing these beautiful rule statements and like a whole book about it. In this case, I would focus mostly on hearsay. I think that's really the key to this essay, although you still definitely want to introduce the relevance issues. Okay, let's finish up call number 3. So these are actually, now that we look at the, well, let's go through the checklist before I jump too far ahead. Logical relevance, okay, legal relevance, exclusions based on public policy. We have a statement that goes to whether she should pay meds, whether Donna's Pizzas should pay for medical expenses. That is one of the exclusions for public policy. So there are a few rules under FRE that allow you to allow you to exclude them if it's for public policy reasons. Let's see here. So offers to pay medical expense. So let's first bring up the exclusion. There's two parts to this. Since this is about offers to pay medical expenses, this may be excluded for public policy reasons, but it may still be admissible for other purposes to prove ownership and control, impeachment, etc. I'm going to write down both. I think that just by virtue of Donna talking about medical expenses, she might be implying, or she is implicitly saying that even though we got into an accident because of Aaron, who was driving Donna's Pizza's car, there might be something to do with proving the ownership or control of the car. This also helps us continue with the discussion, assuming that we can talk about this. Talk about the Pete's testimony here. So based on this, you can actually come to different conclusions here. You can say that, we can't talk about Pete's testimony about Don's statement because it was an offer to pay medical expenses. Or you could say it was brought in to prove ownership or control of Donna's Pizza's car. So whatever it takes to come to a conclusion here. Again, this is similar to Aaron's statement because we have a personal testimony, so we're going to copy over competency of witness. And again, this is a hearsay. We do have prior inconsistent statement. This is about pay medical expenses or not. And similar to Aaron, we have an admission by party, by opposing party. We have Donna, party opponent. We don't have any similar vicarious admissions because Donna is the owner of Donna's Pizza, so there's no vicarious employee relationship between Donna and Donna. Present sense impression. No, this is different because Donna, so Pete is saying that Donna visited him in the hospital. So this is very attenuated from the actual event. Let's go through. Let's see. So we did this quickly, but Donna testified. She was a witness. And let's see. There's nothing about impeachment or character evidence. All right. What else do we have here? We went through this. Declarant is available. We crossed this out. Then existing state of mind. Nope. Physical condition. Nope. No business records or recollection going on here. So I feel like maybe the issue here is about the offers to pay medical expenses. That definitely triggers this rule. So they are typically inadmissible, but if we can use it for other purposes, maybe even admission, proving ownership or control. So there are some ways we can use to bring this in as a not a non-hearsay, but hearsay but accepted statement. But depending on what you come up with here, just because there are some hearsay issues that we could talk about, if it were me, I would try to use these other purposes type of argument to say that the exclusion for public policy does not apply, or maybe it does, and you can conclude that this is likely not admissible. So this is kind of up to you. So I'll leave this up to you. And so that's about it. So this took about 25 minutes, but again, I think that if you go through enough of these similar questions, similar fact patterns, similar issue patterns that correspond to the fact patterns, then you should be able to pump this out in a lot less time. But once you have this all outlined out during the exam or while practice, you just kind of plug in the rule, assuming you know the rule, and then connect the rules to the facts, and then make a conclusion for each of these issues. And then don't forget to answer the calls here. So that is an issue outline. If you were issue spotting, if you were haphazardly trying to pull out whatever you remember at the time or whatever seems familiar, would you have remembered to put everything down here? So maybe you saw that it was a part inconsistent statement. Would you have considered that it was a party admission, or vice versa? I think if you know the issues, so I say memorizing the law or knowing the law is not just about knowing the rules, it's about knowing the issues as well. The issues are at least as important as rules. If you don't have the right issues, then you're not going to even be able to recite the rules, let alone the application and the conclusion. And you'll be losing out on a lot of points if you do not have the issues. So I just want to emphasize that you want to have this sort of issue outline every time you do an essay, unless you're so good at it that you don't need it. In which case, why did you spend 30 minutes with me? I'm so flattered. But in most cases, this is a much more organized way to approach any type of issue, any type of essay. And every subject has its own way of approaching things. So in evidence, you want to check these things for each item of evidence. That's not applicable to contracts or torts or real property, whatever. So you do want to get enough exposure to multiple essays in each subject, ideally so that you hit different issues. And don't forget to don't be afraid to redo the same essays. Just because it seems familiar doesn't mean you are cheating. That's actually the point of practice. You want to be familiar with the issue patterns so that the next time you see it on the exam, maybe you'll remember, oh, I did something just like this in practice. So hopefully you're not just assuming that you'll come up to the plate and be at your 100%. There's a quote that I really like in terms of applied to bar prep. It's by this ancient Roman person. He said, "We don't rise to the level of our expectations. We fall to the level of our training." So the more you train, the more your minimum level that you are capable of goes up. On the exam, you will run into a lot of issues. You might get lost. You might not have lunch. You might be super nervous. You are not going to be at 100% on the exam, despite the adrenaline. The adrenaline will pump you up to 120%, but then all the other things will drop you down to like 90%, 80%, 70%. So you can't assume that you'll be at your best condition. You're not going to rise to the level of your expectations. You're going to fall to the level of how solid your training was. So I would encourage you to work through these essays. Don't. I know it's scary. It's not as straightforward as choosing an answer bubble on the MBE. And coming up with these things is difficult. I mean, this was a difficult essay. There were many different hearsay issues that might be hard to remember, easy to miss. And definitely compare your answers to the model answers, the sample answers that the state bar gives you, student answers, Barbari's model answers. People say to avoid Barbari's perfectly written model answers, but I would disagree with that. You don't have to emulate the giant walls of text that they provide, but they do give you a good sense of how to set up the issues, how to set up the flow of the issues. That's actually what I used to kind of come up with this idea that issues are so important. They will organize the issues in the way that is palatable to the grader. So you don't have to, again, emulate the Barbary essay model answers perfectly, but at least you can shoot for the stars rather than trying to scrape by with the bare minimum, trying to reach just minimal competency. You want to be several levels above minimal competency so that when exam time comes, something might happen and then you will fall to the level of minimum competency. You will fall to the level of your training. So yeah, just use those really good answers as inspiration. I'm not saying you have to copy them. You don't have to be as good as them, but you can use them as inspiration. So hopefully this helped. Let me know if you have any questions, and if you want to check out another issue spotting walkthrough, there's one about corporations and torts on my channel. So if you're interested, check that out. And until the next video, hopefully this helped. Thanks a lot.